Right. We now take up the second case on today's docket, which is Kraft versus the state of Florida. Counsel, you may proceed.
Thank you, Chief Justice Kennedy. May it please the court. Mose Bracey on behalf of Mr. Kraft. I hope to focus on one multi-part claim for relief today. That claim draws on issues 2 and 4 in the initial brief and point 4 in the reply brief, which deals with harmless error. In short, this case should be remanded for, at a minimum, a reevaluation of the mitigating evidence and sentence because 1, the trial court erred when it failed to affirmatively show that all believable, uncontroverted mitigating evidence had been considered and weighed. 2, the trial court assigned the same little weight to the childhood trauma mitigating circumstance that it assigned to the good behavior during trial mitigating circumstance. And 3, at least considered cumulatively, those errors were not harmless. With that in mind, this case is about honoring society's interest in the fair administration of justice and the integrity of judicial proceedings. And this case, and it's about honoring those interests by ensuring that any man sentenced to die is treated as a uniquely individual human being, and that any death sentence imposed is subject to meaningful appellate review. So I hope to make 5 main points in support of this multi-part claim for relief. 1, considering and weighing all believable, uncontroverted mitigating evidence is critical to satisfying the 8th Amendment. In fact, affirmatively showing that any such evidence has been considered and weighed is critical to satisfying the 8th Amendment. 2, even though Mr. Kraft invited the possibility of the death sentence in this case, the trial court was still required to consider and weigh all believable, uncontroverted mitigating evidence.
Counsel, can I ask you about that?
Yes, sir.
It seems like the mitigating evidence issue it seems like the fountainhead for that is Docket. And in Docket, it talks about the 8th Amendment requiring the court to consider mitigating evidence that the defendant proffers as a basis for a sentence less than death. And I've tried to see if there's any Supreme Court case law that says that the 8th Amendment requires sentencing courts to affirmatively seek out and consider mitigating evidence. And I've looked at our statute on death sentencing, and I don't see any obligation like that there. And so I'm wondering, what is our authority to require courts to do that? I understand anything the defendant proffers clearly under the 8th Amendment has to be considered, but what's our authority for requiring anything more than that?
Well, the short answer, Justice Muniz, is the 8th Amendment. And if I could, I believe to answer your question, if I could circle back to the couple of main points I made and elaborate, that may help.
Can I ask you one before you do that, though?
Yes, sir.
So if it's the 8th Amendment, obviously we have a conformity clause. Do you accept the premise that the U.S. Supreme Court hasn't held that courts have to affirmatively seek out mitigating evidence? I just want to make sure there isn't a case or something that I'm missing there, because I haven't been able to find that.
Well, Justice Muniz, I'm frankly, I couldn't cite you to a particular case that says that exactly. However, I do think that any fair reading of the United States Supreme Court precedent construing the 8th Amendment would lead to the logical conclusion that that is the case, and certainly against the background of the United States Supreme Court precedent construing the 8th Amendment, this court has certainly said that. And I believe that the reason this court has said that is because of the U.S. Supreme Court precedent on that issue. If I could elaborate on that point, however, again, I believe that,
excuse me, sir. Before this, I have something that's sort of related. You're asserting a harmless error standard in this context, and the harmless error cases that I've seen relate to a failure to consider proffered mitigation that's offered and argued as mitigation by the defendant. And I found at least one case where there was a waiver of mitigation and we looked at fundamental error. And so I'm curious as to why we would not be looking at fundamental error for things that the trial court didn't consider, even assuming that you're right that the Eighth Amendment does require that we put the affirmative obligation on the trial judge to do that, why would it be a harmless error standard when it's clearly not something that's preserved? It wasn't even proffered, it was waived.
Well, Justice Lawson, one, I would respectfully ask that if this court was to decide these issues on the basis of what you're outlining, I would respectfully ask for the opportunity to be heard on that in written form. I mean, the state did not raise that, and so I would ask for supplemental briefing on that. However, what I would say to that is that my reading of the cases is that when mitigating evidence is improperly considered and weighed, that is subject to harmless error analysis. I believe that in some of the cases I cite, although I'm not 100% sure on this, Justice Lawson, however, I could elaborate in supplemental briefing, but I'm not sure, for instance, in Robinson versus State, which is a case that we rely on in issue 2, I don't believe there that, my understanding is that Mr. Robinson, I believe he waived his right to present mitigating evidence. And even so, the court there said that it was reversible error for the court to have not considered and weighed all the believable uncontroverted mitigating evidence. I'm not sure if a harmless error analysis was expressly conducted in that case, but I would just maintain that this type of error should be subject to harmless rather than fundamental error analysis. I think that's consistent with this court's precedent, but of course I would welcome the opportunity to elaborate on that in a supplemental briefing. I would also briefly take the position that it would be fundamental error in these circumstances. But if I could take a step back and try to reapproach this from a broader perspective, and I hope some of what I am about to say will address some of the points that have already been raised. I think that, well, the United States Supreme Court has said that a fundamental respect for humanity underlies the Eighth Amendment. And they've also said that that respect requires the consideration of mitigating evidence. And this last part, quote, is as a constitutionally indispensable part of the process of imposing a sentence of death, end quote. And that's from Woodson versus North Carolina. The court's also gone on to say, I believe in Penry versus Linnell, that only when mitigating evidence is considered and weighed can we be assured that the capital defendant has been treated as a uniquely individual human being. Furthermore, only then can we be sure that any determination that death was the appropriate sentence is reliable. And so against that background, this court has long said, and in fact, this is a quote from Muhammad versus State, this court has repeatedly emphasized that the trial court has a duty to consider all mitigating evidence contained anywhere in the record to the extent it's believable and uncontroverted. And I'm aware of that principle going back at least to 1993 in Farr versus State from 1993. It goes back at least that far. And it was in Farr. In Farr, this court actually, in Robinson in 1996, this court noted that in Farr, that general principle had been extended to cases in which the defendant didn't present mitigating evidence and, in fact, argued in favor of the death penalty. So I would start with that general proposition that considering and weighing all believable, uncontroverted mitigating evidence is critical to satisfying the Eighth Amendment. I would also go on to point out that affirmatively showing it has been considered and weighed is critical. And again, starting with the U.S. Supreme Court, I would note that it has said that meaningful appellate review is critical to ensuring that any death sentence is properly imposed. Furthermore, they've noted that meaningful appellate review is only possible when the senator, quote, specifies the factors it relies on in reaching its decision to impose death. And again, against that backdrop, this court has said that to ensure meaningful appellate review, the senator has to meaningfully and comprehensively analyze the mitigating circumstances. And then
if I can, excuse me, but redirect to the specifics of your issue 2. You allege 9 circumstances where you say the trial court failed to consider mitigation that was in the record. And with respect to almost all of those, it looks to me as if they fit within the categories. The way the trial judge did the order, he narrowed down all the mitigation he could find in the record, or thought that he could find, into categories like childhood trauma, close family ties, mental health mitigation, and good behavior during trial. And my question is, what mitigation do you point to that doesn't fit within those categories that the trial judge clearly considered?
Well, Justice Lawson, I don't believe the nine circumstances, the nine instances of mitigating evidence would fall within those four categories. And if I could list those nine pieces of evidence, one, Mr. Kraft was born with the umbilical cord around his neck. He was blue in the face and not breathing when he was born. Two, his mother didn't seek proper mental health treatment and believed that she could beat it out of him. That's a quote.
And why aren't both of those things childhood trauma?
Well, Justice Lawson, I think they're certainly not mentioned explicitly in the court's consideration of childhood trauma. I do think that if we step back and look at it in a big picture, we could say that those would be traumatic events. Yes, sir. However, I would take the position that the court did not. It would be a stretch for this court to say that those things were considered and weighed here. And again, I would return to the fact that this court has said, going back to 1996 in Robinson v. State, that it's the court's duty to affirmatively show that all believable, uncontroverted mitigating evidence has been considered and weighed. And
Mr. Bracey, just to follow up on that, I want to understand then from your perspective what an adequate record would be of the court's consideration of childhood trauma in a case like this. What kind of record should the court make under the rule you're proposing?
Yes, sir. Yes, sir, Justice Coriel. Well, what I would say is this. I believe that the applicable general rule here is that the trial court affirmatively show all believable, uncontroverted mitigating evidence has been considered and weighed. Now, I do appreciate that that's not a strict rule, and it's not strict in the sense that a court's not going to be able to go through some checklist in each case to satisfy it. In other words, the court's going to have some discretion in applying that rule. And of course, that means that on appeal, this court's task is going to involve drawing some degree of line drawing. And so, Justice Coriel, it's hard for me to say exactly what a proper application of that rule would look like in every case. But I would say that this case is an outlier. It falls on the wrong side of the line. And I would suggest it's the rare case. Well, if I could say this, as we all know, a trial court abuses its discretion when no reasonable person would take the view adopted by the trial court. And here I would say that this is the rare case in which no reasonable person would take the view that the trial court affirmatively showed all believable, uncontroverted mitigating evidence had been considered and weighed. So ultimately, I would fall back on this being the rare case in which the trial court abuses its discretion here. Now, if I could touch back on this notion of, or this main point I outlined earlier, that even though Mr. Kraft invited the possibility of the death sentence, the trial court was still required to consider and weigh all believable, uncontroverted mitigating evidence. And again, I'd want to start with the United States Supreme Court, which has said that a defendant's interest in self-determination or autonomy is not absolute. Instead, there are times where a defendant's interest in autonomy has to yield to society's interest in the fair administration of justice and the integrity of judicial proceedings. And so there are a few instances where that takes place, where that interest yields to society's interests. For instance, there are circumstances where even over a defendant's objection, a trial court can terminate self-representation and appoint counsel. Furthermore, on appeal, that's categorically the case. The court can appoint counsel over a defendant's objections. And then finally, and perhaps most relevant, there are circumstances, even where there's just a possibility of a conflict of interest, a trial court can refuse to honor a defendant's waiver of conflict-free counsel and refuse to allow the defendant to be represented by counsel of his choice. So again, against that background, this court has said, going back 40 years, that the rights, responsibilities, and procedures outlined in the constitutions and statutes are not suspended simply because a defendant invites the possibility of a death sentence. Furthermore, and more specifically, this court, and I believe this starts in 1993 and far, But I know the court also said this again in Fitzpatrick in 2005, but this court has said that a trial court's duty to consider all believable uncontroverted mitigating evidence, quote, applies with no less force, end quote, where a capital defendant asked the court to not consider mitigating evidence. And furthermore, where a defendant invites the possibility of a death sentence. So again, I think that case law is certainly consistent with the United States Supreme Court precedent. I think it is dictated by the United States Supreme Court precedent. And certainly if this court was inclined to recede from that precedent, again, I would respectfully ask for the opportunity to address that in supplemental briefing because I would argue that even if reasonable minds could disagree as to whether that general rule is appropriate, it's not clearly erroneous. And so I would respectfully ask the opportunity to address stare decisis on that precedent. Now, if I could proceed to my third main point, which is basically that no reasonable person would take the view that the trial court here affirmatively showed that the believable uncontroverted mitigating evidence had been considered and weighed. And I would just start by pointing out that there doesn't seem to be a dispute that certain evidence was before the court, that it was mitigating, that it was believable and uncontroverted. The main dispute seems to be whether it was considered and weighed properly. And I would basically just say that this situation is like Robinson versus State. In Robinson, the trial court did consider some mitigating evidence, but there was other mitigating evidence that received little or no discussion in the sentencing order. And I believe that Robinson should dictate the outcome on issue 2 in this case. Now, if I could touch on the second part of this multi-part claim for relief, which is that the trial court erred in assigning the same little weight to the childhood trauma mitigating circumstance that it assigned to the good behavior during trial mitigating circumstance. And there, I would start by pointing out that in the portion of the sentencing order that considered the childhood trauma, the trial court indicated that Mr. Kraft's family member statements were credible and unrefuted. And I would argue that this case on this issue is similar to Ramirez versus State. And in Ramirez, in essence, what happened was the trial court assigned less weight to the no significant history of prior criminal activity mitigating circumstance. And it did so based on a judgment that reaching through an open window of a pickup truck and stealing $10 off the dashboard was significant prior criminal activity. And on appeal, this court said, in essence, that was an abuse of discretion. That was unreasonable. And similarly here, I believe that the trial court reasoned that the childhood trauma evidence, mitigating evidence, in essence, should be assigned less weight because the evidence was insufficient to establish that it had an ill effect on Mr. Kraft. But I would argue that just as in Ramirez, here, that was an unreasonable conclusion. And first of all, I would point out that based on the nature of Mr. Kraft's adult life, it was self-evident that trauma had an ill effect on him. In short, by the age of 30, he's essentially volunteered to be on death row. But even if that was not the case, I would argue that in this day and age, any reasonable person, particularly any reasonable person with any experience in the criminal justice system, would appreciate that the childhood trauma of the kind and to the degree that Mr. Kraft endured, that would have an ill effect on that person's health, development, and ability to function. And if I could briefly I don't want to get too bogged down into the mitigating evidence, but if I could briefly point out 2 instances that I believe are microcosms concerning the quality of the mitigating evidence here. In this case, Mr. Kraft's aunt testified that there were instances where his mother at the beginning of the month would collect the government check and disappear on a drug binge. In those instances, his aunt, who was his mother's youngest sister, would look after Mr. Kraft and his siblings. And there were times where all she had to feed the kids were crackers and ketchup until the crackers ran out. There was one other instance where she was called out in the middle of the night because Mr. Kraft had run off. She found him in some bushes out by some railroad tracks near his house. It was raining. It was the middle of the night. He came running out of the bushes wearing only a soiled pair of underwear. He was about 10 years old and he had welts on him from head to toe because he'd been beaten. And so again, I would take the position that on issue 4, no reasonable person would have assigned the same little weight to the childhood trauma circumstance that it assigned to the good behavior during trial circumstance. I would also point out on this issue that just as no expert testimony was required in Ramirez to establish that stealing the $10 was not significant prior criminal activity, the same is true here as far as establishing that childhood trauma of this kind and to this degree would have an ill effect on Mr. Kraft. And then lastly, if I could touch on the harmless error issue, my basic position there would be that even if these errors did not substantially influence the trial court's decision to impose death, that a reasonable possibility exists that they contributed to that decision. And I would note that the reasonable possibility standard is an extremely low standard. And I would argue that if this court was to conclude that no reasonable possibility existed here, that it would be in effect substituting itself for the trier of fact and reweighing the evidence, which is not allowed under the harmless error analysis. I would also point out that in these circumstances, in this situation, when considering this type of error and failing to properly consider and weigh mitigating evidence, this court has, in essence, often applied a three-factor test. That test considers whether the aggravation is substantial, whether the mitigating circumstances that were considered and weighed were numerous, and then finally, whether the circumstances that were not properly considered and weighed were minor and tangential. And applying that test here, I would argue that on the one hand, the court did find 4 aggravating factors. On the other hand, it only considered and weighed 4 non-statutory mitigating circumstances. And as to one of those, the childhood trauma, it erred in weighing that circumstance. Most critically, the factors here that were not properly considered and weighed, those factors were not minor and tangential. Instead, they painted a compelling portrait, as to use words that this court has used before, it painted a compelling portrait as to why Mr. Kraft succumbed to the passions and frailties inherent in the human condition. And so I would argue that this case is similar to Crook v. State, that own this issue of harmless error that Crook should control. Are there any further questions?
I guess my only question is, you said that you would, and I know you haven't had a chance to really think this through, but what would be your no fundamental error argument, given the very serious aggravators and the great weight properly given to HAC and CCP? I'm struggling to see how, if fundamental error is the standard, you could argue that. So,
yes, sir. Well, Justice Lawson, at this point, I think the best answer I could say would be that these errors vitiated the basic validity of this second phase capital sentencing process. And I believe that it would be equivalent to the denial of due process in the sense that it fails to satisfy the Eighth Amendment. And again, I would come back to the fact that, well, first of all, I would say this, Justice Lawson, in Furman, Justice Stewart said that death differs not only in degree, but in kind from any other criminal punishment. First of all, it's irrevocable. Second of all, it rejects rehabilitation as a basic purpose of criminal justice. And then finally, it rejects our basic concept of humanity. And I think it rejects our basic concept of humanity in the sense that, once death is imposed, once a person is executed, they are beyond redemption. And at that point in time, that rejects our basic concept of humanity. And so against that background, I think the U.S. Supreme Court has made it clear that for a death sentence to be appropriate, the case has to be not only among the most serious, but the defendant's culpability has to be extreme. And I think that's the same thing as this court saying that for a death sentence to be appropriate, the case has to be among both the most aggravated and least mitigated. And so here, even if we assume this case is among the most aggravated, the question is it among the least mitigated? And I would say that here, where the trial court failed to consider believable, uncontroverted, compelling mitigating evidence in multiple instances, I would argue that in that case, we cannot say under the Eighth Amendment that it's among the least mitigated. And as a result, it would be the equivalent of a denial of due process. It would vitiate the basic validity of this proceeding. That would be my basic argument there, Justice Lawson. And I would just come back one last time to the fact that even though Mr. Kraft invited the possibility of the death sentence, the courts, including this court, still have to honor society's interest in the fair administration of justice and the integrity of judicial proceedings. And here, where the trial court, where the senator failed to consider all the believable, uncontroverted mitigating evidence, this court simply can't say that that happened. As a result, we can't say that the death sentence was reliable and that Mr. Kraft was treated as a uniquely individual human being. Unless there are additional questions at this point, I would reserve the balance of my time for rebuttal.
All right. You hit it right at 5 minutes. So your timing is impeccable. Counsel, you may proceed.
May it please the court, Chief Justice Kennedy. My name is David Chappell, and I am the Assistant Attorney General representing the state in this matter. This case arises from a brutal prison murder wherein the defendant, Mr. Kraft, strangled and beat to death a fellow inmate. He confessed to the crime to the jailhouse personnel, subsequently confessed to the crime to the law enforcement personnel who interviewed him, and again confessed to the crime during the trial court proceedings in this case. Now, counsel began with the discussion of issue 4 in this case, specifically whether or not the trial court considered and weighed all of the mitigating evidence that it was presented. As Justice Lawson pointed out, the trial court in this case grouped all of the mitigation that was presented to it into 4 categories. And this court has repeatedly held and encouraged trial courts to group mitigating factors, especially in cases where the defendant has chosen to waive the presentation of mitigation. Moreover, in this case, the defendant never requested that the trial court explicitly list out all of the individual mitigators the defendant wished the court to consider. Accordingly, the trial court did a very admirable job of crafting a sentencing order that highlighted many of the individual things that defense counsel now on appeal has articulated as it failing to even consider, including under the childhood trauma that the defendant's mother allegedly used drugs while she was pregnant with the defendant. These are individual mitigating factors that the court did in fact consider. And indeed, the court also made sure to include in its sentencing order that it reviewed all of the exhibits, considered all of the evidence, and reviewed all of the testimony before coming up with the mitigating factors that it found in this particular case.
Mr. Chappell, could I ask you a question? Do you agree that one of the alleged items that was not considered was saving a fellow inmate's life? Another was prior work history. And would you agree that those wouldn't fall into any of the categories or groupings that the trial judge set forth in the order?
Yes, Your Honor, that does appear to be the case. However, that being said, the state would still argue that any error in this case is again either invited because the defendant didn't specifically request that the trial court list out each individual piece of mitigating evidence that it wanted the court to consider, or alternatively, that the error here was harmless. As this court has held repeatedly, the aggravators that are present in this case are some of the most egregious that can exist, specifically HAC, CCP, and prior violent felony offense. Accordingly, even if the trial court should have listed out additional factors or additional mitigators, or even if this court determines that the trial court in this case should have weighed particular mitigators in a different way, the error is ultimately harmless here because of the aggravators that are present in this case and the fact that those aggravators were some of the most extreme that can exist in a capital death penalty case. Now, the defendant also argues in issue 2 that the trial court erred specifically by not assigning more weight to the childhood trauma mitigator that it found in this case. First, I would like to point out that the way the defense is arguing this doesn't seem to be based in law anywhere. Specifically, the defense claims that the court erred because it weighed the childhood trauma or gave it the same weight that it provided to the good behavior the defendant showed in the courtroom. This court has never held, nor does it appear that any court has ever held, that a trial court must look at all of the mitigators presented and evaluate each mitigator in comparison to the other mitigators that are in the record. So the defense's argument on this point seems to be without basis in the law with respect to that. As far as the weight that the court specifically assigned to the childhood trauma mitigator, first it's important to note that the court did do an individualized sentencing order with respect to this, and it evaluated the testimony of the family members who testified during the defendant's penalty phase here. And it specifically went through the evidence that it reviewed and articulated that it found that there was evidence to find that the mitigator existed. So this is not a case where a trial court has failed to find a mitigator that was in the record. Rather, this is a case where what is at issue is the trial court's weighing of that particular mitigating circumstance. And since the defendant in this case was found competent to proceed, chose to represent himself, and was allowed to put on the case that he desired to put on, the trial court faulted the presentation of evidence in terms of tying the childhood trauma to the man the defendant had become, whether it materially impacted him at the time that this murder had occurred. And the fact that there was not evidence presented by the defense in terms of establishing that. And in order for this court to reverse the trial court's the weight that the trial court assigned to that mitigator, this court would have to conclude that no reasonable person would have agreed with the trial court's interpretation of this. And here again, the trial court was in the best position to weigh the evidence, to evaluate the defendant, and to review the record and see all the witnesses that testified on his behalf. And the state's position is that the trial court did not err with respect to assigning little weight to the childhood trauma mitigator. Also important to note, as was noted in the state's brief, there have been other cases in which this court has affirmed on direct appeal trial court sentencing orders where the trial court has assigned little weight to a childhood trauma mitigator, specifically Lynch v. State, which is cited in the state's brief. Lastly, even if this court determines that the trial court should have assigned more weight to the childhood trauma mitigator, this, again, issue is subject to harmless error analysis. And again, because of the fact that the statutory aggravators here were some of the most severe that can exist in a capital case, the state contends that there is no, any error that occurred would be harmless in this case. The state has nothing further to present, and we respectfully request that this court affirm the defendant's judgment and sentence.
Can I ask you a question, counsel? What's your view on what the Eighth Amendment requires as far as going beyond considering mitigating evidence that the defendant proffers?
The state did not brief this particular issue in this case, in that particular context. That being said, the state does not have an objection to this court revisiting that precedent and taking a harder look at applying the conformity clause and following the United States Supreme Court precedent in terms of limiting it to the defense, the mitigating evidence that the defense actually wants to present.
Is that your understanding of where the Supreme Court's jurisprudence stands right now, that it's limited to what's put in front of the court by the defendant?
I believe that seems to be the direction that the court is going in. In particular, it was, I believe, a recent 2018 case, McCoy v. Louisiana. Justice Ginsburg articulated a position that was very much in favor of defendants having the autonomy to present the case that they wanted to present, and the fact that if they are competent to proceed and are not disruptive during courtroom proceedings, that the defendants do have a constitutional right to present the case that they choose to. And in context of a death penalty case, that absolutely would include the presentation or lack of presentation of mitigating evidence.
Okay, thank you.
Thank you.
All right. Thank you, counsel. Counsel, you may proceed.
Thank you, Chief Justice Kennedy. Justice Muniz, if I could return to the last point you asked about, I would argue this: under the Eighth Amendment, for a death sentence for a death sentence to be determined to be reasoned and individualized, mitigating evidence has to be considered. And I would argue that even where a defendant fails to proffer mitigating evidence, even where a defendant invites the possibility of a death sentence, at least the believable uncontroverted mitigating evidence has to be considered in order to ensure that any resulting death sentence is reasoned and individualized. Furthermore, in order to ensure that sentence is reliable and reasonably consistent under the Eighth Amendment, I would argue the same thing, that at least the believable, uncontroverted mitigating evidence has to be considered and weighed. I think if this court was to recede from its precedent, which clearly going on 30 years now has said, at least 30 years, has said that a trial court has to consider all believable, uncontroverted mitigating evidence. If this court was to recede from that precedent, then significant Eighth Amendment issues would arise under this state's capital sentencing scheme. And again, if that was a direction this court was inclined to go, I would ask for supplemental briefing on that.
And how does that work in the context of states where it's jury sentencing for the death sentence? I mean, in that case, aren't they just considering what the parties put in front of them?
Well, I believe that it would depend on which particular system we're talking about. I mean, I think that in many states in which there's a jury role in the capital sentencing process, it is like Florida in the sense that a trial court has an additional role to play. But again, I would argue, I mean, I believe that under those systems, of course, I can't say this for sure, Justice Muniz, but I imagine that the jury is instructed to consider all mitigating evidence presented, and I would assume.
Right, and I think that's the point, though, is that the jury obviously isn't in a place to go and seek out additional mitigating evidence beyond what the defendant puts in front of it. And I'm assuming that we can't have whatever the Eighth Amendment requirement is. I mean, it's got to be something that makes sense for both systems.
Right. And I imagine that under those systems, if it was a situation where no mitigating evidence was being considered at all, then it would be problematic from an Eighth Amendment perspective. And that challenges would be made on that basis, that at least the senator should consider the believable, uncontroverted mitigating evidence. So that's the basic point I want to emphasize, is that I believe it will be extremely problematic under the Eighth Amendment if this court was to recede from precedent and no longer require the senator to consider all believable, uncontroverted mitigating evidence. And I would just emphasize, this is not all mitigating evidence. It's only the believable, uncontroverted mitigating evidence. So it's not a burden that's extremely high on the senator here. And again, I would just return to this notion that a defendant's interest in autonomy has to be balanced against society's interest in the fair administration of justice and the integrity of judicial proceedings. And so, again, I think if this court was to recede from the precedent this court has clearly said that even when a capital defendant argues in favor or death or asks the court not to consider mitigating evidence, that the duty to consider all believable, uncontroverted mitigating evidence applies with no less force. So again, even if reasonable minds could disagree, those decisions are not clearly erroneous. And I would argue that this court should respect and abide by its prior precedent. If I could just briefly touch on a couple of things the state mentioned. One, if we were to assume here that the trial court considered and weighed the mitigating evidence at issue in issue 2, this court would not be able to conduct meaningful appellate review. It would only be able to assume that it was considered. It would only be able to substitute itself for the trial court and decide if any error was harmless. It would only be able to substitute itself for the trial court most critically and determine that this case is among the least mitigated. So again, it's critical that the trial court affirmatively show that it specified the factors it relied on in reaching this decision to impose death. And if I could just sum up with a few brief sentences, this case is an outlier. It's the rare case in which, in multiple instances, the trial court failed to consider and weigh believable, uncontroverted, and compelling mitigating evidence. As a result, Mr. Kraft was not treated as a uniquely individual human being. Furthermore, we can't be sure that the determination here was reliable. As a result, in those circumstances, I would ask this court to honor society's interest in the fair administration of justice and the integrity of judicial proceedings, and I would ask this court to do so by reversing the death sentence imposed below. Thank you.
Okay, thank you, counsel. We thank you both for your arguments in this case. The court will now stand in recess for about 10 minutes before we take up our next case.